Hi there, welcome to Employment Law Show. John Scholes, Lior Samfiru. We are back for another week. We are glad you are too. Reaching out anytime throughout the show. You will see the contact information on your screen there, 1-855-821-5900. Lots of stuff to get through on the show over this next half hour, Lior, including your guide to wrongful dismissal in Canada. That is on the way. You want to reach out anytime, help@employmentlawyer.ca. And we always tell you to check out pocketemploymentlawyer.ca as well. That is a free website, completely anonymous for you to use anytime, anywhere. Lots of information to be had, and there is contact at the top right, but you can just turn off your browser and nobody knows you were ever there. Again, pocketemploymentlawyer.ca. But we always start with the week that was. Pal, how are you?
John, doing great. Very excited always to be here. Always a privilege to have the opportunity to answer questions about employment law, to talk about workplace rights, to hopefully help people understand what their rights are, how to solve their problems, and what to do if you're facing a workplace issue, because there are solutions. Workplace law is still here. Employment law still operates. It's still here. It can still help you. And what we try to do on this show is to tell you what you need to know about your legal rights. We always should care about employment law. It always governs our job, so that's a very important thing. But right now, in the current situation, with the current pandemic and economic situation, employment laws are that much more important. That's why we want to touch on that. And if you want to talk about your matter specifically, if what we talk about on the show today doesn't cover your situation exactly, not a problem. We'll give you my contact information throughout the show. You can reach out to me, you can phone, you can email. Let's have the talk about your rights, and I'm happy to help you. About a week, there was a situation that came across my desk very recently. I spoke with a woman this week who had been off for a while now in a layoff because of COVID-19 and was called back to work. Well, first thing she did as soon as she was called back to work is to make some phone calls to see if she can find childcare. She had a 3-year-old son, and she wanted to make sure that, of course, she had childcare. She made some calls. The usual place where she sends her child, the daycare, was accepting a lot less children, so there was no room for her or for her child. She made some other calls, and she could not find anything. She was told maybe in 60 days or 90 days there's going to be some more room, but right now there was no room. She spoke to her employer immediately, and she said, I've tried to find childcare. I can't, so I need to stay at home. If you need me to work, I'm happy to work from home, but I can't come into the office because of the fact that I don't have childcare. Well, her employer was very clear and said, well, that is your problem. Because childcare centers are open, you're expected to be back to work. And if you're not going to be back to work, there's not going to be a job for you. Well, obviously very upset, she called me and she wanted to know, what does she do here? She can't leave a 3-year-old alone, and her employer is saying she has to come in. Well, here's the thing. Now that you have some options with respect to childcare, you are expected to make some reasonable efforts to find care for your child. You are expected to see if there's options, if you can have someone take care of the child, or if you can take them to a daycare center. You're expected to make those efforts. But sometimes, despite those efforts, you may not be able to find any childcare. It's more difficult right now. There's less spaces. And if that's your situation, if you can still not find childcare, that means you're allowed to stay off work. You cannot be penalized. You cannot be punished in any way, shape, or form. And in fact, at this point, you can also continue getting government benefits like the CERB. So your employer can't tell you, too bad, that's your problem. No, it doesn't work that way. Now, you can't simply say, I'm just staying at home and I'm not even going to try to find childcare. But if you've tried and you cannot find childcare, your employer has to allow you to stay off work or work from home if that's what makes sense. If you're in a situation where your employer is giving you a hard time, not being cooperative, threatening you with a termination or a resignation, you really want to reach out to me, because chances are that's completely illegal.
Yeah, it's an interesting story, and I think you're going to get more of those. I mean, speaking from personal experience, my niece is going through that, and her daycare is, as you said, partly open with fewer spaces for kids. And the ones that are open are being first made available for frontline workers. Right. So they get first dibs, and then other kids, if there's room, they can come in. And you can't just shove your kid off to another daycare they've never been to. They're familiar with the other kids and the daycare workers, so they got some leverage there for sure. Employmentlawyer.ca, by the way, is the website you can go to anytime. While you were there, you can catch past shows of this nature and our radio show, which we've been doing for, I think, over 8 years now. Hard to believe, but we have. We take the phone calls from that show and we talked about them here on TV. It's kind of weird, but it works. And we'll get to the first call for the day, pal, right now.
My brother-in-law is a mechanic, has been employed with his last employer for about 10 or 12 years. For a number of years, he's been doing the odd oil change in his own garage on behalf of family, friends, and a few others. His employer has been fully aware of this and fired him and said to him he would be receiving absolutely no severance whatsoever. Where do you think he will be going as far as termination?
How old is he?
55.
That's a very interesting scenario, and I remember getting that call on our radio show. So here's how this works. Yeah, I would generally have concerns on behalf of the employee if you're working for a company as a mechanic and you're also doing jobs on the side for some friends and family, because there could be a conflict there. But despite what I just said, if the employer knows about it, has known about it all along, guess what? They cannot then punish you for it. Your employer can't decide to punish you for something that they knew you were doing, they've approved you doing, and they can't decide one day, hey, now I've decided today that I'm going to be considering that to be unacceptable and I'm going to let you go. That doesn't work this way. So this person was wrongfully dismissed. We'll talk more about wrongful dismissal later on the show because of the fact that even though what they have done may not have been right, if the employer accepted it, it becomes fine. And that same applies to you. If you do something that strictly speaking you're not allowed to do, if your company allows you to do that, they're considered to have condoned it. Condone that behavior, and if they condone that behavior, they cannot fire you from it.
Right.
So, John, now that we know that this person was wrongfully dismissed, we know, therefore, that he's owed severance. So, to find out how much severance he's owed, let's plug his information into pocketemploymentlawyer.ca and see exactly what he's owed. So this person is a technician or a mechanic, has been there for 12 years, 55 years old, was not paid severance, incorrectly, of course. So we can see right on Pocket Employment Lawyer that he's owed right around 16 months' pay. 16 months' pay. You know, depending on his income, that could be easily 6 figures or more. So that's how easy it is to use pocketemploymentlawyer.ca, and that's the difference between being terminated legally or illegally. For this person, it's right around $100,000 difference. It's a big deal.
TerminationQuestions.com should mention that as well. Anytime you want to go there and leave a question, do some research there as well. It's another outlet for you to get some more information about employment law for yourself or friends or a family member. TerminationQuestions.com. We'll get to the first one for today. This one comes from Simon. Lior Simon says, I was temporarily laid off months ago and at the start of the COVID-19 pandemic. While some of my coworkers have been called back, I have yet to receive the phone call. I'm beginning to think it won't ever come. What should I do now?
I've been getting this question often, as you can imagine. Some people even say, well, they're calling back more junior people than me. I'm more senior. They're calling back the juniors. What can I do? So this is not so much about who the company is calling back. It's a question of whether or not they had a right to lay you off to begin with. And regardless of what they're doing right now, the company, remember the rule, and I've said this before on the show, is that your employer does not have a right to unilaterally lay you off, even if it's because of COVID-19. You may have the right to treat that layoff, that temporary layoff, as a termination of your employment and require the company to pay severance. Now, if you've decided to wait, like this person, they've decided to stay at home and see what happens. If they're not called back to work, well then treat that as a termination right now. If you decide to accept the layoff and sit home and wait, well, it's really up to you at that point to decide how long you're going to stay and wait. You can do it for a month, for 2 months, or for whatever it is you decide, keeping in mind that your employer did not have a right to lay you off to begin with. So my advice to this person is, if you haven't been called back yet, you don't believe you're going to get called back, why are we sitting on our rights? Let's get your severance right now, and let's move on to a different job. And of course, pocketemploymentlawyer.ca can help you find out in seconds how much severance you're actually owed.
Is there something else that person should fear, that if they do stick around and they do eventually get called back, maybe they're making less, maybe they have fewer hours, and in 6 months from now, if they get let go for real, that could affect how much severance they get, right?
That's a huge thing. I've been seeing that left, right, and center.
Right.
You're being called back to work, but with less pay or less hours. Well, the problem with that, other than the obvious, is that if you are then let go, the company may say, well, we're going to pay you severance based on those reduced hours. So you end up losing on the severance front as well. That's why it's really important when you're either laid off or if your company changes terms of employment to really start thinking about constructive dismissal. Do we want to treat that as a termination? Because what we don't want to have happen is say, okay, I'll be the good soldier, only then to be let go and realize that if you had stood up for your rights earlier, you would have gotten more compensation. So if you're in a situation, in a dilemma, you're not sure what to do, what your rights are, should you pursue constructive dismissal? Should you pursue severance? Just give me a call, and I'm happy to talk you through it.
Let's take a quick break and get back to, wrongful dismissal, a guide to it, and if you're working in Canada, that is on the way. In the meantime, 1-855-821-5900 and help@employmentlawyer.ca. It's Employment Law. She'll stick around. We're coming right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show. John Scholes. Again, Lior Samfiru for the remainder of this half hour. Glad you're here. Glad you stuck around. You want to reach out anytime. You can call 1-855-821-5900. And the email address is help@employmentlawyer.ca. And always, first place you go, even before the phone call, especially if it's like 2 in the morning. I mean, I'd call Lior at 2 in the morning, but you don't have to. He probably wouldn't like it. You want to go to pocketemploymentlawyer.ca. That is the place. But, Lior, let's get to this. Wrongful dismissal in Canada. Before we talk about wrongful dismissal why don't we talk about what wrongful dismissal is not?
That is definitely a good place to start because there's a lot of misconception about what a wrongful dismissal is. And usually when I get a call from someone that has been let go or someone that believes that they've been wrongfully dismissed, it starts something like this. The company didn't have a good reason, so they let me go. Therefore, I've been wrongfully dismissed. Well, that's actually not a wrongful dismissal. A wrongful dismissal does not have to do with the reason, generally, that the company lets you go. And that is because an employer is allowed to let you go at any time and pretty much for any reason as long as they pay you severance. So you may disagree with the reason, or even the reason that they gave you may be false. They may tell you we're restructuring, but you know that they're hiring someone to replace you. So clearly they're not restructuring. Despite that, that's not illegal as long as you get paid your severance. Now, that may make them not nice people or unethical, but it's not illegal. So generally, the reason, even though you disagree with it, even though you think it made me made up or false or unfair, the reason has nothing to do with being a wrongful dismissal. So you may have been let go for a bad reason, John, but that's still not a wrongful dismissal.
Okay, that's what it isn't. So tell us what it is in Canada anyway.
Well, what flows from that really is that a wrongful dismissal is all about severance. In other words, wrongful dismissal is simply a situation where you've been let go and have not been paid proper severance. That's what a wrongful dismissal is. Nothing to do with the reason. The reason may be legitimate or illegitimate. If you've been let go without proper severance, you were owed 12 months severance, you were offered 7, 6, 2, whatever it is, less than what you're owed, you've been wrongfully dismissed. So when we talk about the word wrongful, it almost suggests that the employer is doing something wrong. Well, what the employer is doing wrong in a wrongful dismissal is letting you go without the severance that you're owed, and that is a very, very common thing.
So if you see 100 dismissals in a week come by your desk, how many of those would qualify as wrongful dismissals, do you think? Is it common?
I see more than 100, but let's say it was 100, about 90 of them,
wow.
John, 90, and I'm being conservative, 90 of them are going to be wrongful dismissals in the sense that the individuals are offered a lot less than what they're owed. And I'm not talking about I'm owed 12 months pay and they offered me 11. That's still maybe a wrongful dismissal, but it may not be a huge wrongful dismissal. I'm talking about situations where someone is owed 12 months pay and they're offered 6 or 3. That's the gap that I'm seeing, and I've been seeing this for the almost 20 years that I've been practicing law. So a wrongful dismissal is actually common. Most terminations are wrongful dismissals. You may be watching right now and you lost your job a year, 2 years, 10 years ago. Well, I can tell you right now, you may not have realized that at the time you were wrongfully dismissed. Most people are. That's the bad news. The good news, we'll talk about that soon, is it's not difficult to resolve, and it starts with going to pocketemploymentlawyer.ca to find out what you're owed.
You know, every week we like to talk about and throw around legal terms, and we explain them. So people are thinking, okay, now I've heard wrongful dismissal. Before that, you've talked about constructive dismissal. What's the difference?
So a constructive dismissal is simply a type of wrongful dismissal. A constructive dismissal happens when the company did something that forced you to leave. They mistreated you, harassed you, they changed your job, you changed your pay. They did something they were not allowed to do, and as a result, you chose to treat that as a termination and get severance. So in that situation, because the company has yet to pay you severance, that's a wrongful dismissal. So a constructive dismissal is a type of wrongful dismissal. If I tell you you've been constructively dismissed, essentially you've also been wrongfully dismissed. And I've seen that many times, and we talk about this on the show very often. Probably one of the most common types of wrongful dismissal is a constructive dismissal, especially now during COVID-19. We see pay cuts, changes to hours, temporary layoffs. All those things are constructive dismissals. All those things, therefore, are also wrongful dismissal.
Well, we know that once you get involved, there's going to be a severance package looming. Is the deadline on that severance package, is it enforceable?
So remember what I said, that most severance offers are completely inadequate. Most people, in fact, are wrongfully dismissed. Well, all severance offers have a deadline. Well, essentially what the deadline says is, we're offering you less money than what you're owed, because that's what most employers do. And to accept this amount that's less than what you're owed, you have to sign this by Friday. Well, that's nonsense. That's ridiculous. If you're owed 12 months' pay, you should get 12 months' pay, and that deadline means nothing. So that deadline is a pressure tactic, and so many people sign it because they think if they don't, they're going to lose something. It doesn't work that way. Your rights are what they are. Your legal rights don't expire on Friday or Tuesday. In fact, you have up to 2 years before your legal rights go away. So don't fall for that pressure tactic. Remember, if you've lost your job, chances are, very high chances, in fact, that you've been wrongfully dismissed. If you sign off on that severance package, despite that deadline, despite that pressure tactic, it's too late to do anything about it. The best advice I can ever give anyone that's lost their job, call me, go to pocketemploymentlawyer.ca, speak to another employment lawyer if you don't like me, but do something other than accept it, because then once you do, you'll find out it's too late.
So off the top, you've been let go, possibly wrongfully dismissed. What are the first steps? What do you do first?
Well, first thing you do, and this has to be the first thing because it's so simple, you go to pocketemploymentlawyer.ca. You grab your smartphone, you grab your tablet, your desktop, what have you, and you go to pocketemploymentlawyer.ca. And why? Because we have a tool there that allows you to find out if, in fact, you've been wrongfully dismissed. It calculates your severance. We may as well be calling it the wrongful dismissal calculator. It allows you to find out how much you're actually owed. And then you simply compare what you're owed with what you've been offered, and if there's a gap, then you've been wrongfully dismissed. And then you can contact me if you want directly from pocketemploymentlawyer.ca. You can always just call me directly if you don't want to go to pocketemploymentlawyer.ca. But you have to keep in mind, if you're staring at that severance letter, today was your last day, here's your walking papers, you can almost guarantee that whatever's outlined in those walking papers is less than what you're legally owed. In most cases, that's what happens. Either the company doesn't know what they're supposed to pay, or they hope that you, the employee, don't know. Either way, you're owed more. That's why we made it as easy as possible and anonymous and free. Couldn't be easier. Just go to pocketemploymentlawyer.ca.
I want to flip back to the radio show, which we mentioned and used a phone call from it in the first part of the show. Again, employmentlawyer.ca is the website you want to go to catch a radio show near you. At least search a station where you can find us each week and have been for the last 8 or so years. We'll get to our second phone call for today, pal, right now.
My wife's been working for, we'll say, a large bank for over 10 years. Over the last couple of years, she's had some health issues, and just kind of resulted in her not being at work as much as possible. And they say, well, your output of work has lowered over the last 2-3 years out of your, tenure. And she's saying, well, obviously it has. I'm not there as much. She's doing as much or more as anybody else in the office if you were to look at the actual numbers. It feels as if they're kind of trying to force her out.
Yeah, and I've seen this many times. You're struggling maybe with some health issues, your employer is noticing that, or maybe they know something's going on, they don't know exactly what it is, and now they're saying, well, let's push this person out, maybe they're not as reliable as we wanted them to be. Well, the starting point, you need to protect yourself, and the way you protect yourself is you get something from a doctor. You get a doctor's note. I know you may not want to tell your employer you have a medical condition, but trust me, if your medical condition impacts your job, if it impacts your performance in any way, even slightly, tell your employer. And not only just tell your employer, get something from a doctor. Because as soon as you provide something from a doctor that says, yes, this person has these limitations, it may impact their job, now you have this dome of protection around you. You cannot be let go. You cannot be demoted. Your hours can't be changed. You can't be considered to have resigned. You can't be pushed out. Nothing can happen to you, but you need that doctor's note. Because if your employer tried to do anything to you in the face of knowing that you have a medical condition and in the face of getting something from a doctor, that becomes a human rights violation as well. It's illegal. So I understand the trepidation. You don't necessarily want to tell your employer. You're afraid it makes it worse. The problem is if you don't tell your employer can do pretty much whatever it wants, and other than severance, there's not much that you can get. So give that doctor's note. Make sure your employer knows, and if your employer mistreats you, you have to give me a call. There's significant consequences. The other thing is this: if you need some accommodation, maybe you need modified hours or modified duties. Maybe the job is now too difficult to do physically because of your physical limitations. Not a problem. Your employer still has to accommodate. Just make sure you get something from a doctor. Once you do, your employer has a very strict duty to accommodate. So it starts and ends, frankly, with a note from a doctor.
All right, we'll take a short pause here, pal. Coming up here, red flags in an employment agreement. This can affect all of us. You do not want to miss it, so stick around for that. More of the Employment Law Show is on the way. We'll be right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. We'll get to another phone call. By the way, we pull these from our radio show. You can be found anytime, employmentlawyer.ca. And always remember to go to pocketemploymentlawyer.ca. That website is absolutely free and anonymous, and there's a wealth of information for you anytime there as well. Phone call number 3, Lior. Let's get to it right now.
I'm being transferred, I guess, like changing companies, not really voluntarily. My responsibilities are getting a little bit more, but my pay isn't going to be affected. I'm all of a sudden being forced to sign documents to say that I'm now working for a new company with a new employee handbook that talks about dismissal without severance. I am being asked to sign documents that I will never try to advance myself or get a promotion.
How long have you worked with the existing company?
Around 9 years.
You can hear my disapproval at the beginning. No way.
No way. And there's really a lot to unpack here. And I remember telling this person when they called us on the radio shows, you got to call me off air. I want to actually see the documents, because it's almost too much to just talk about, in a radio show or a TV show. But bottom line is this. Your employer is changing terms of employment. That's what's happening. They're transferring him. They want him to sign a new document, give him a bit of different responsibilities. All those are changes. Now, depending on the changes, maybe he's happy with them, maybe he isn't. But if he's not, that's not something his employer is allowed to do. And then to make matters worse, they want him to sign documents giving up severance. So, John, one of the scenarios could be he starts with this new transferred company and he signs this document. 2 months later, they let him go, and now he could potentially be getting 8 weeks severance instead of 12 months severance. That's how big a deal it is. Anytime you're asked to sign a document by your employer, be careful. There's a reason an employer wants you to sign a document. It's not because they like things on a piece of paper. It's because there's a legal reason where they're trying to protect themselves, and that's fine. But your responsibility as the employee is to protect yourself as well. Now, this person, if he refuses to sign, he may be terminated, but that's okay. That's okay. It's better to be terminated getting your full severance than actually signing something then being terminated, realizing you walked away from entitlement. So just for fun, because we've been talking about it throughout the show, let's take this information, or this person's information, and plug it into pocketemploymentlawyer.ca and see what he'd be owed. So I'm not sure what his role is. Let's say he's a professional. We know he's been there for 9 years. Let's say he's 51 years old. You can see right at the bottom, he's owed anywhere from around 12 to 14 months pay, up to 14 months of severance. Now, John, if he were to sign that document limiting his entitlements and then he's let go, that 14 months becomes 8 weeks.
Ugh.
So 14 becomes 2. That's why it's so important not to sign anything giving up your rights. And if you're not sure if you're giving up rights, if you're not sure what it means, send me a copy of what your company wants to sign. Let me see it. Let me tell you what it means and if you should be concerned about it.
I want to get to terminationquestions.com. We used this before. We'll get to another question from it, Lior. This one comes from Tony. Tony says, a major incident forced me to take long-term disability due to severe stress. Since I started LTD a year ago, I've been harassed by the adjuster who just last week cut off my claim due to insufficient medical support. I'm not ready to work, but have you been trying unsuccessfully to contact my employer about returning?
So obviously there's two aspects to this matter. There's the disability issue as well as the employment issue. So let's deal with the disability issue first. If he can't work, if his doctor backs him up, if his doctor says, yeah, he cannot work, it's not up to the adjuster to say, yeah, no, I don't believe you, you should be working. It doesn't work that way. The adjuster is not qualified to make that decision. And frankly, an insurance company is in the business of trying to get people off disability coverage, not to keep them on. So probably one of the best things that you could do right now is have us deal with the adjuster, maybe remind the adjuster that he is allowed to be off on a disability leave and get the adjuster off his back. You should not be cut off your insurance, your disability insurance, if you cannot work. Insurance company may try, and oftentimes when we get involved, they'll either back off or we can negotiate some compensation to make it all resolved. But no, your doctor, what your doctor says is what matters. And with respect to your employer, if you are ready to come back to work and you're trying and the company is not responding, they're not cooperative, it's as if they've terminated your employment. If you tell your company, hey, I'm ready to come back from a disability leave, when can I start? They don't get back to you, they're not helpful, they keep putting you off. It's as if they've terminated your employment. You can then pursue severance, and potentially it's also a human rights issue. If your company refuses to take you back because you took a medical leave, because you have a disability or had a disability, that is illegal. That's a human rights issue. So there's a lot there, and if you ever find yourself in that situation, by all means, give me a call. We can help you with both the disability issue and the employment issue.
Again, terminationquestions.com is where you want to go to leave those questions. We've got a couple minutes left, so I'll slide one more in for today, Lior. This from Abdu says, how long can my employer keep me working on reduced hours? Can I refuse after a certain amount of time has passed and my hours haven't been restored?
So the short answer is your employer can't keep you on reduced hours at all. You can treat that as a termination of your employment and require them to pay you severance. There's no law that says they can do it for 2 weeks or 8 weeks or any other period of time. It's however long you decide to give them that opportunity. So what I would say to Abdu is this. Tell your employer right off the bat that you're only agreeing to these reduced hours for a period of time. 2 weeks, 6 weeks, 8 weeks, a specific period of time. You set that period of time. Don't ask your employer to set it. And if your employer doesn't bring you back to your regular hours, your regular pay at the end of that period, you can then treat that as a termination and say enough is enough. If you don't do that, if you simply continue working your reduced hours, you may be considered to have accepted it. Now you're stuck with those hours. Your employer may never bring them back. If you are let go, you're going to get less severance. So that's why it's so important to tell your employer right off the bat, I'm only agreeing to this temporarily.
And any correspondence, as you always say, it's got to be in writing, right?
If it's not in writing, it does not exist. Words to live by.
We're going to wrap it for another day. Thank you for joining us. And you want to reach out now that we are done. 1-855-821-5900. help@employmentlawyer.ca. That is the email we refer to. And a couple times you heard us go to terminationquestions.com. You can leave your questions there, and we might get to one on the show here as well. And always, 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 the pocketemploymentlawyer.ca website is like having an employment lawyer right in your pocket, hence the name. Use that whenever you want, and there's contact there as well. So we'll catch you next time here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.